under 21A. Group number 4 consists of petition number 19, again filed by legislator belonging to the UBT faction under 21B, challenging the defiance of whip with regards to the speaker's election. Group number 6 consists of petition number 21, again filed by legislator belonging to the UBT faction under 21B with regards to defiance of whip for the confidence motion. Group number 5 consists of petition number 22 to 24, which has been filed by legislator belonging to the Shinde faction under 21A and 21B. Group 2 consists of petition number 17, which has been filed against certain independents and members belonging to other parties under 2 subclause 2. So we shall, before I proceed with the judgment, pronouncement of the order, I would like to express my sincere gratitude towards the Honorable Supreme Court of India, which has provided an extremely guiding force by way of its order, whereby they have given a direction to the whole adjudication of the issues being decided in the proceedings today. Therefore, I would at the outset express my gratitude towards the Apex Court. At the same time, I would like to express acknowledgement and a big thank you to the staff of the state legislature who have assisted me and the paralegal assistance which I have received from them during the course of the conduct of these proceedings pertaining to disqualification. I would also like to appreciate the cooperation which I have got from counsels appearing on both the sides, and I shall now proceed with the pronouncement of the order. As we are aware that there are certain preliminary issues which are applicable to all the 5 groups out of the 6 groups, and therefore I shall first commence with my ruling on the preliminary issues which concern all the 5 groups. Thereafter, I shall pronounce the operative part of the orders concerning each group and the relevant and important paragraphs pertaining to each group. So we shall commence with group number 1. Preliminary issues. The Honorable Supreme Court in Subhash Desai Supra versus the Governor of Maharashtra, hereinafter referred to as Subhash Desai, was pleased to direct that the Speaker should prima facie determine who the real political party is for the purpose of adjudicating disqualification petitions if 2 or more factions claim to be that political party, and accordingly shall recognize the whip and the leader who were duly authorized by the Shiv Sena political party, keeping with the principles discussed in the said judgment. Hence, keeping in view the factual matrix and the directions of the Honorable Supreme Court, I will prima facie determine who the political party is for the purpose of adjudicating disqualification petitions if 2 or more factions claim to be that political party, and accordingly recognize the whip and the leader who are duly authorized by Shiv Sena political party. Keeping in mind principles discussed in Subhash Desai Supra, it is necessary to consider and determine the said preliminary issue before examining the merits and deciding whether respondents have incurred disqualification under the 10th schedule of the Constitution of India. Thus, the preliminary issue that arises for my consideration before delving into the merits of disqualification petitions under the 10th schedule is, which among the 2 fractions was the real Shiv Sena political party and consequently who was the duly authorized leader and or the whip of Shiv Sena political party for the purpose of deciding the present disqualification petition. The other issue framed for my consideration in this group of disqualification petition is whether the respondents have incurred disqualification in terms of paragraph 21A of the 10th schedule of the Constitution of India on account of their alleged acts and conduct. Paragraph 84 deals with the principles which have been laid down by the Honorable Supreme Court. I am not going to read out those are a part of my order. I'll come to paragraph number 85 now. Thus what emerges from the principles laid down by the Honorable Apex Court in that the question of who the real political party is has to be considered and determined after giving due weightage to 1. The Constitution of Shiv Sena, 2. The leadership structure of the party, and 3. The legislative majority if two or more factions claim to be real political party. The question of who the real political party is hereinafter referred to as the preliminary issue. Since in these proceedings both in the previous paragraphs I have recorded the submissions made by both the parties. I will come down to my observations and conclusions with regards to the preliminary issues. As stated earlier, the decision of the preliminary issue has to be taken after careful analysis of the Constitution of Shiv Sena, the leadership structure of the party and the legislative party majority. After having heard both sides on the above aspect, I now propose to proceed to record my observations and finding on the preliminary issue. As is evident from the submissions of the parties, there is no consensus on the Constitution submitted to the Election Commission of India with consent of both the factions. Likewise, the parties have different point of view on the leadership structure which has to be taken into consideration. The only aspect which is undisputed is the majority in the legislature party. Hence, to embark upon the finding on the preliminary issue, I will have to decide the relevant constitution which has to be taken into account. 2. The leadership structure which existed before the dispute arose. Further, it will also have to be determined as to when the rival factions emerged. Petitioner's assertion that the Constitution of the year 2018 is the relevant constitution which has to be taken into account for the purpose of determining the preliminary issue is based on the submission that 1. The 2018 Constitution has to be considered as both the parties have relied upon the 2018 amended Constitution and acted thereupon. 2. The Election Commission in its order dated 17/2/2023 in dispute case number 1 of 2022 has held that both the parties were aware of the 2018 amendment and thus the said Constitution of 2018 has to be taken as the Constitution which is done with the consent of both the factions, as the said Constitution of 2018 was never disputed prior to the initiation of these disqualification petitions and the same was never challenged. 3. Respondents have themselves admitted and relied on the said Constitution of 2018. And 4. The statement of Sri Yogesh Kadam that the filing of 2018 Constitution along with the respondent's reply was a mistake done by the lawyers cannot be accepted, as the said statement is an afterthought and done only with the intention to mitigate the damaging statements made by Sri Dilip Lande. To the contrary, respondents have asserted that the Constitution of the year 1999 has to be the one which has to be borne in mind, as according to the respondents, the Constitution of the year 2018 was never submitted to the ECI. Respondents pointed out to the letter dated 4th April 2018 by way of which the petitioner based their claims of submissions of the said Constitution to the ECI. By pointing out to the same, respondents submitted that both the said letters do not mention anything about the purported amendments to the Constitution a submission of the same thereof to the ECI. A similar claim was made with respect to the letter dated 27/2/2018 by Shri Uddhav Thackeray in the special leave petition number 3997 of 2022. However, in the said SLP, there was no mention about the existence of any such letter dated 4th April 2018. The word submitted appearing in paragraph 168 of Subhash Desai means submitted before the ECI, as is evident from the further part of the said paragraph, which the petitioner has conveniently ignored. The respondents have further submitted that 2018 Constitution has been wrongly annexed as a document. The stand of the respondent on the 2018 Constitution has always been that it is unconstitutional and was secretly manufactured by Shri Uddhav Thackeray in cahoots with Mr. Anil Desai. This stand has been specifically taken in the reply filed by Shri Eknath Shinde before the Honorable Supreme Court in SLP number 3997 of 2023, way back on 16/3/2023, much before filing of the replies before the Speaker in August 2023. Further, even the additional replies filed on 25/10/2023 in the present proceedings, the aforesaid petition has been reiterated by the respondents. After having considered the submissions advanced by both the parties on the question as to which is the relevant constitution for the purpose of determination of the preliminary issue, I have come to the following conclusion. A. As per the Honorable Apex Court, if both the factions have submitted different versions of the constitution of the party, then in that case, what has to be taken into account is the constitution which was submitted to the ECI with the consent of both parties before the rival factions emerged. Before recording further conclusions, I find it imperative to reiterate that, pursuant to the initiation of these disqualifications, the Maharashtra Legislature Secretariat had vide letter dated 7 June 2023 requested the Office of the Election Commission of India to provide a copy of the party constitution / memorandum / rules and regulations The Election Commission of India, with a letter dated 22nd June 2023, provided a copy of the Constitution and rules of Shiv Sena as available on the record of Election Commission of India. Further, with respect to amendments, if any, to the said Constitution of the party, the Election Commission requested the Legislature Secretariat to refer to the order dated 17 February 2023, passed by the ECI in dispute case number 1 of 2022. Having perused the same, it has to be noted that the copy of the Constitution of Shiv Sena provided by the ECI does not bear any date or year, but as per the ECI, that which is provided vide the reply is the only Constitution of Shiv Sena available on the record of the ECI. Further, with respect to the amendments, if any, to the said Constitution, the Election Commission, vide its order dated 17 February 2023, has held in paragraph 132 4b that the amended Constitution of 2018 is not on the record of the Commission. Thus, the petitioner's submission that the Constitution of the year 2018 has to be taken into account cannot be accepted, as I am bound to follow the directions of the Honorable Apex Court in Subhash Desai Supra, and accordingly take into account the Constitution which the Election Commission has provided. In my jurisdiction under the 10th schedule of the Constitution of India, I cannot delve into any other factor while deciding which is the relevant Constitution. As prima facie, it is evident from the records of the ACI that the 1999 Constitution is the one which was submitted to the ECI by the Shiv Sena before rival factions emerged. Further, it is also necessary to mention that the petitioner's submission that the Constitution of the year 2018 was submitted to the ECI by referring to the letter dated 4th April 2018 cannot be accepted. A bare perusal of the said letter dated 4th April 2018, by way of which the petitioner based their claim of submission of the said constitution to the ECI, does not bear any content which shows that an amended constitution was submitted to the ECI. The said letter only refers to the election held and the results thereof, and nothing more. Further, on closer examination of the special leave petition filed by Mr. Uddhav Thackeray before the Honorable Supreme Court, challenging the ECI decision SLP number 3997 of 2022, I find that exactly same claim has been made about the letter dated 27/2/2018, and there is no mention about the new letter of 4th April 2018. Accordingly, said letter of 2/7/2018 is on the website of the Election Commission of India. However, there is no document relating to the constitution annexed to it. Hence, on this ground also, petitioner's submission that the constitution of the year 2018 has to be taken into account cannot be accepted. Petitioner's submission that submitted before the speaker, petitioner's submission that into inverted submitted before the speaker would mean into inverted annexed by the petitioner and the respondents in their respective petitions and replies thereto cannot be accepted, as there is a clear provision under the 1986 rule where the leader has to submit the party constitution. Rule 3 subclause 1 subclause B of 1986 rule mandates that the leader into inverted shall furnish into inverted a copy of the rules and regulations, whether known as such or as constitution or any other name, of the political party concerned. Further, Rule 3 subclause 4 contemplates that whenever any change takes place in the information furnished by the leader of the legislature party under Rule 3 subclause 1, he shall as soon as may be thereafter, and in any case within 30 days from the date on which such change has taken place, or within such further period as the speaker may for sufficient cause allow, furnish in writing information to the speaker with respect to such change. Thus, the submission of constitution before the speaker has to mean submission under Rule 3 of 1986 rules. However, till date, Shiv Sena has not submitted any constitution on the record of the speakers of the speaker under the said Rule 3. In view of the above observations and finding, I need not further analyze any other submission in this regard made by the parties, and I hold that the constitution of Shiv Sena provided by Election Commission of India, vide letter dated 22nd June 2023, is the relevant constitution of Shiv Sena for determination of the preliminary issue as to which faction is the real political party. Constitution of Shiv Sena held to be the relevant constitution is hereinafter referred to as the SS Constitution. The leadership structure relevant for the determination. Learned Senior Advocate Mr. Kamath's submission that the leadership structure which is relevant for the purpose of deciding the preliminary issue is the leadership structure which is reflected in the communication dated 27 February 2018 and 4th April 2018 made to the Election Commission of India pursuant to the elections held on 23rd January 2018 is based on the petitioner's submission recorded in paragraph 89A to G herein above. Initially, the petitioner relied on the affidavit submitted to the ECI of the then office bearers of Shiv Sena produced along with the affidavit in lieu of examination of chief to show that Shri Uddhav Thackeray had support of the majority in the organization. Respondents objected to such production on the ground that it is not permissible to produce affidavits of others along with petitioner's own affidavit in lieu of chief examination without the author of the said affidavits subjecting themselves to cross-examination. In any event, during the arguments, Mr. Kamath did not rely on these affidavits and limited his submissions to the 2018 leadership structure as available on the ECI website. Mr. Jethmalani, in turn, focused his submission to buttress the ground that the said leadership structure of 2018 cannot be considered and relied upon for the purpose of determining the preliminary issue, as the said leadership structure is not in conformity with the constitution of Shiv Sena, which is on record of the ECI, and thus the same would be contrary to the findings of the Honorable Supreme Court in paragraph 168 of Subhash Desai. Mr. Jethmalani further relied on the legislative party leadership to submit that the legislative party also forms part of the leadership structure, as it is not only mentioned in the SS Constitution, but there is no dispute regarding the said members being part of the Pratinidhi Sabha under the SS Constitution. After having considered the submissions advanced by both the parties on the question as to which is the relevant leadership structure for the purpose of determination of the preliminary issue, I have come to the following conclusion. The submission of Mr. Kamath, the jurisdiction under the 10th schedule, only mandates a prima facie adjudication as to what the leadership structure of the political party was at the relevant time, and it does not extend to an inquiry as to whether or not the leadership structure available on the record of the ECI was pursuant to a validly held election, is a correct position, and hence I concur with the same. Petitioner's submission that in these proceedings the respondents cannot challenge the organizational election results available on the record of the ECI, as the 10th schedule does not permit the raising of any such defense, is a correct position, and hence I am in agreement with the same. Respondent submission that the leadership structure of 2018 cannot be considered and relied upon for the purpose of determining the preliminary issue, as the said leadership structure is not in conformity with the constitution of Shiv Sena, which is on record of the ECI, does not arise at this juncture, as it is a submission which has to be considered while determining whether the said leadership structure can be relied upon for the purpose of determining which faction represents the real political party, which would be dealt with at the appropriate juncture. The only question which is to be determined in the current part of the order is what and who all constituted leadership structure of Shiv Sena at the relevant time. Respondents have led detailed evidence, and despite being confronted during cross-examinations, they have been able to demonstrate that no organizational elections were held on 23/1/2018. On the contrary, in the affidavit in lieu of examination of Chief of Shri Sunil Prabhu, PW1, has stated that organizational elections were held on 23/1/2013 and 23/1/2018. However, Shri Sunil Prabhu has not claimed any personal knowledge of the same or and whether he was present during the said elections. During his cross-examination, he was confronted with the letter dated 28/1/2013. Thereafter, a specific question was posed to him by Mr. Jethmalani as to whether he voted in the said election, to which he responded in the affirmative. The contents of the said letter clearly stated that all the candidates were declared unopposed. The contradiction was also put to the witness by Mr. Jethmalani in cross-examination. However, no justification for the same was put forth by the witness. In view of the above evidence and records before me, prima facie indicate that no elections were held in the year 2013 as well as in the year 2018. However, I, as the Speaker, exercising jurisdiction under the 10th schedule, has a limited jurisdiction and cannot go beyond the record of the ECI as available on the website, and hence I have not considered this aspect while determining the relevant leadership structure. Thus, in view of the above conclusions, I find that the leadership structure of Shiv Sena reflected in the letter dated 27th February 2018, available on the website of the ECI, is the relevant leadership structure which has to be taken into account for the purpose of determining which faction is the real political party. The question whether which faction is the real political party is discernible from this 2018 leadership structure is discussed in paragraph 112 to 131 infra of the present order. The leadership structure so determined as the relevant leadership structure for the purpose of these disqualification petitions are hereinafter referred to as the 2018 leadership structure. Since in these proceedings both the factions are claiming to be the real political party, rival factions have emerged in the Shiv Sena. In view of the fact that rival factions have emerged and both the factions are claiming to be the real political party, it is imperative to prima facie determine when did the rival factions emerge. Thus, it is necessary to determine the relevant day on which rival factions emerged before further venturing into which of the faction was the real political party when rival factions emerged. At the outset, I must set straight the point that the determination of the Speaker exercising jurisdiction under the 10th schedule while deciding who the real political party is mandates only a preliminary inquiry which has to be done prima facie by taking into account material officially before the Speaker as the Master of the Legislative Assembly. I shall consider the facts relevant for the determination on what is before me as the Speaker of the Legislative Assembly. As noted by the Honorable Supreme Court in Subhash Desai Supra, on 21st June 2022, there was no material available before the Deputy Speaker to infer the emergence of any rival faction. However, after taking on record the resolution dated 21st June 2022 passed by the SSLP, disputed by the respondents, the very next day the then Deputy Speaker received a resolution disputed by the petitioner dated 21st June 2022, received by the then Deputy Speaker on 22nd June 2022, contrary to the resolution dated 21st June 2022. Thus, from this fact alone, it is evident that there emerged two factions of the Shiv Sena from 21st June 2022 itself, but the same came to be officially on record of the office of the Speaker and or Legislative Secretariat on 22nd June 2022. At this juncture, it is imperative to refer to paragraph 119 of Subhash Desai Supra, where the Honorable Apex Court, while discussing the legality of the recognition of leader and the whip of Shiv Sena, accorded by the letter dated 3rd July 2022, held that the Speaker ought to have taken into consideration the split that took place within the Shiv Sena, which were discernible from two sets of resolutions appointing two different leaders and whips placed on the record by Shiv Sena before the Legislature Secretariat. This paragraph into bracket 119 read with Honorable Apex Court's finding recorded by the Honorable Apex Court in paragraph 157 of Subhash Desai Supra makes it clear that the law laid down by the Honorable Supreme Court is that in view of the deletion of paragraph 3 of the 10th schedule, when rival factions emerge as a result of rift stroke split in the party, the Speaker has to necessarily find which faction is the real political party while recognizing leader and the whip of the party. Thus, in view of the facts recorded in the preceding paragraphs and keeping in view the principles enumerated by the Honorable Supreme Court in Subhash Desai Supra as recorded in paragraph 84 herein above, I have come to the following conclusion that the emergence of the two factions of Shiv Sena can be inferred from 21st June 2022 itself, and the same came to be a matter of official record of the office of the Speaker and or the Legislature Secretariat on 22nd June 2022. Conclusion: having decided the 1. relevant constitution of Shiv Sena, 2. leadership structure, and 3. the relevant point of the the relevant point for the purpose of determining the preliminary issue, I have made the following analysis, observations and determinations on the preliminary issue of which faction was the real political party when two factions emerged. For the purpose of analyzing, discussing and determining the issue, the faction of the petitioner is hereinafter referred to as UBT faction, and likewise the respondent's faction is referred to as the Shinde faction. The applicability of the test of aims and objectives. I am not going into the details of reading the applicability of the test of aims and objectives, because as you are aware that in accordance with the directions of the Apex Court and otherwise, the speaker is not required to get into the political thicket with regards to the aims and objectives of a political party. So I am restricting it to pronouncement, and you can have a look at it once you apply for the certified copy. The reason why Shiv Sena constitution assumes significance is to analyze whether the question of which faction is the real political party is discernible from the leadership structure identifiable from the said Shiv Sena constitution. So the Shiv Sena constitution is relevant to the extent of identifying the leadership structure. Leadership structure as a criteria to determine who was the real political party. As I have already held which is the relevant constitution and the leadership structure of the Shiv Sena to be taken into account for deciding the preliminary issue, I now have to see whether the relevant leadership structure read with the SS constitution provides answers to the question which faction is the real political party and consequently determine the same. The UBT faction made, there are submissions made which have been recorded of both the sides, which are at paragraph 113 and 114 of my order. In view of the above recorded submissions of the parties, there emerges two further questions: whether 2018 leadership structure is in conformity with the constitution of Shiv Sena. Number two, whether will all the Paksha Pramukh whether will of the Paksha Pramukh and or majority leaders in the 2018 leadership structure could be said to be synonymous with the will of the political party. So we further have to derive get answers to two more questions. The primary one being whether 2018 leadership structure is in conformity as provided by the constitution, and number two, whether the will of the Paksha Pramukh and or majority of the leaders reflects the will of the political party. As there are contrasting submissions on the question, it is necessary to peruse the SS constitution and the 2018 leadership structure and then record a finding as to whether the 2018 leadership structure is in conformity with the constitution of the Shiv Sena. Thus, I have taken a comparative look at the 2018 leadership structure and the SS constitution and have arrived at the following observations and conclusions. A. 2018 leadership structure mentions Shiv Sena Paksha Pramukh into bracket president as the highest office of the SSPP. However, in the SS constitution, the highest office of the Shiv Sena political party is Shiv Sena Pramukh, but the said constitution distinguishes highest office and the highest authority and provides that Rashtriya Karyakarni is the highest authority whose decision shall be final. Shiv Sena SS constitution provides that the members of the Rashtriya Karyakarni shall be called as Shiv Sena leaders and provides for a total number of 19 members, out of which 14 are to be elected by the Prathinidhi Sabha and the rest of the 5 members are to be appointed by Shiv Sena Pramukh. However, the 2018 leader structure envisages only 13 members in the Rashtriya Karyakarni, out of which 19 are to be elected and the remaining 4 are to be appointed. SS Constitution provides for a total number of 21 deputy leaders, out of which 17 are to be elected by the Pratinidhi Sabha and the rest of the 4 members are to be appointed by Shiv Sena Pramukh. However, the 2018 leaders structure envisages 33 deputy leaders, out of which 21 are to be elected and the remaining 12 are to be appointed. The 2018 leadership structure provides for 3 categories of office bearers, vis-a-vis Secretary, Samanvayak and Sanghatak. However, the Constitution of Shiv Sena provides for 3 categories of office bearers, vis-a-vis President, Sar Chitnis, General Secretary, Koshadhyaksha, Treasurer. From the observation recorded in the preceding paragraphs, it is evident that the 2018 leadership structure is not at all in conformity with the Constitution of Shiv Sena. In view of this finding alone, it could very well be concluded that the 2018 leadership structure, which is not in conformity with the Constitution of Shiv Sena, cannot be taken as the yardstick to determine which faction was the real political party at the relevant point of time. In view of the same, I have come to the conclusion that the 2018 leadership structure read with the SS Constitution does not provide a reliable outcome and or answer the question which faction is the real political party, and hence cannot be relied upon to determine the said preliminary issue. Nevertheless, I am inclined to look at the second question regarding paragraph 115 herein above, where will of the Paksha Pramukh and or majority leaders in the 2018 leadership structure could be said to be synonymous with the will of the political party, so as to not leave any stone unturned in arriving at a decision. The determination of this question arises out of the alternate submissions made by the UBT faction that the 2018 leadership structure has to be taken ex facie, and the determination of which faction was the real political party has to be solely based on the said leadership structure without a comparison of the said structure with the leadership structure provided for in the Constitution of the Shiv Sena. The said proposition would run counter to the principles laid down by the Honorable Apex Court in Subhash Desai Supra, where it was specifically provided that the leadership structure which has to be taken into consideration while determining the real political party has to be identifiable by the relevant constitution. Thus, although in the light of my finding on the preceding question, the aspect need not be looked into, however, I intend to look into the said aspect any which way, considering the gravity and importance of the dispute. Hence, following are my observations, findings and conclusions on the said aspect. UBT faction has submitted that the decision of the Paksha Pramukh is synonymous with the will of the political party, and thus if there is a rift in the leadership structure, the decision of the Paksha Pramukh constitutes the will of the political party. This proposition is devoid of merit, as I do not find any substance to allow the same. The reason for the same are recorded herein below. The proposition perhaps would have been a valid point if the party president was the sole repository of the decision making with respect of the policy and administration of the party. For analyzing the said submissions, a perusal of the SS Constitution was made. The SS Constitution provided that Rashtriya Karyakarni shall be the highest authority of the party, and its decision in all matters concerning the party policy and party administration shall be final. It is also to be noted that the Paksha Pramukh is only a presiding member of the said highest authority in the party, and in no way is the sole repository of decision making in the party. Thus, in view of the same, the submission that the decision and or the will of the Paksha Pramukh is synonymous with the will of the political party cannot be accepted. It would be appropriate to note that the SS Constitution does not even have a post called Paksha Pramukh. However, it was argued by the UBT faction that the nomenclature difference in the 2018 leadership structure and the SS Constitution is not a relevant factor for the purpose of deciding the preliminary issue. Even though I have held in paragraph 117 that 2000 leadership structure is not at all in conformity with SS Constitution, I shall consider this submission. The Constitution of Shiv Sena provides for Shiv Sena Pramukh. The submission of the petitioner that Shiv Sena Pramukh mentioned in the SS Constitution is the same post of Shiv Sena Paksha Pramukh termed in the 2018 leadership structure. By relying on the powers of Shiv Sena Pramukh, it was argued by the UBT faction that he is the authority under the party constitution vested with the powers to remove any member of the party. Thus, it was further argued that an authority who is vested with such power of removal reflects the will of political party with respect to removal of members from and for anti-party activities. However, a complete reading of the said provision in the party constitution reveals that the said submission is factually wrong. The said provision in relation to the powers of Shiv Sena Pramukh clearly provides that such a power is not absolute and it has to be exercised in consultation with the Rashtriya Karyakarani. Further, it has to be noted that such a power is only available to the Shiv Sena Pramukh for the purpose of removal of members mentioned in Article 8, Schedule B of the said constitution. The said schedule does not deal with leaders of the party. Leaders of the party is given under Schedule A of the said article. Thus, Shiv Sena Pramukh does not have any power to remove any leader of the party. Thus, the submission of the petitioner that Shri Uddhav Thackeray, Vide, letter dated 30/6/2022, had removed Shri Eknath Shinde from the post of Shiv Sena leader cannot be accepted, as such power are not vested with the party president. Hence, on this ground also, the submission that the decision and or the will of the Paksha Pramukh is synonymous with the will of the political party cannot be accepted. If this proposition is accepted, then in a situation where the party president, who is also a legislator, itself defects, then he could simply escape the wrath of the 10th schedule by pleading that his decision is the will of the party. Further, if this proposition is to be accepted, it would mean that no member can ever voice concern against the party president, and the party president might possibly be able to seek disqualification against any member who questions his credibility. This would run contrary to the concept of intra-party dissent. In view of the clear and unequivocal finding of the Honorable Supreme Court at paragraph 183 to 190 of Subhash Desai, I will be falling foul of the judgment of the Honorable Supreme Court in Kyoto Holohan, wherein the constitutional validity of the 10th schedule was itself upheld on the grounds that it is not an anti-dissent law if this proposition is accepted. I shall now proceed to consider whether the will of the majority leaders in the 2018 leadership structure is synonymous with the will of the political party. An alternate submission was made that even if the Paksha Pramukh is not accepted as the repository of the will of the political party, the decision of the leadership structure has to be construed as synonymous with the will of the political party. This proposition is also devoid of merit, and I do not find any substance in it for following reasons. In a circumstance where there is no dispute amongst the leaders identifiable by the constitution of a political party, the proposition would have held water. However, the factual matrix of the present matter is different. This is a matter where there is a dispute within the leadership structure itself. It is to be noted that in the present matter, rival factions have emerged in the legislature party, political party, and thus inevitably amongst leaders of the party as well. Thus, it would not be wise to apply this proposition in the present matter. The existence of split stroke rift in the leadership structure is admitted by the petitioner and or the UBT faction, as can be inferred from the petitioner's affidavit in lieu of examination in chief of PW1, petitioner himself, that the leader of the UBT faction did not have the support of all the members of the 2018 leadership structure when rival factions emerged. Thus, the submission that the decision of the leadership structure has to be construed as synonymous with the will of the political party could have perhaps be applied in a situation where there is a dispute between some members of the party and the elected leadership. In such a case, the leadership of the party could have possibly taken the stand that their decision would have to be taken as the decision and will of the political party until they are so removed from the leadership structure by a mechanism recognized by the constitution of the said political party. However, as I have noted earlier, in the present matter, rival claims have emerged wherein the leadership structure about the leadership within the leadership structure about the leadership itself. In such a situation, one leader's contention that his will is the will of the political party would be contradiction in terms. Thus, when there is a vertical rift in the party and two factions within the said leadership structure emerge as a result of the said rift, leaders of either faction, both Shri Uddhav Thackeray and Shri Eknath Shinde, could equally claim to represent the will of the political party. In that case, it would not be appropriate to take their decision as the decision that carries the will and wish of the political party when the question of which faction is the political party is being considered. There possibly lies one more aspect which could be considered. Does the stand/stroke decision of the majority members of the leaders within the leadership structure, identifiable and appointed according to the constitution of the political party, could be construed as the will and desire of the political party in the event there is a dispute within the leadership structure? For the purpose of answering this question, one must look into the constitution of the political party. In an event where the party constitution provides for a mechanism to resolve a conflict of decision within the leadership structure, then in that case it would have been a guiding factor. However, if the party constitution does not provide for such a mechanism, then in that case it would not be appropriate to say that the decision of the majority leaders would have to be accepted as the one which conveys the will of the political party. This aspect need not be further considered in view of the fact that in any case UBT faction has not placed any material on record or even suggests that any meeting of the Rashtriya Karyakarni was called for where any decision in relation to the real political party was resolved so as to identify the leaders and or the whip who carried the will of the political party. Thus, in the absence of any such material, including any majority decision of the Rashtriya Karyakarni in relation to the real political party, identifying the leader and or the whip who carried the will of the political party would be an impossible task. Any conclusion reached would be without basis in law and evidence of fact. The submission that the UBT faction shall be taken as a real political party is entirely based on the conjuncture that if there will be a decision taken in relation to the political party by Rashtriya Karyakarni, then UBT faction would have had the majority. At this juncture, the petitioner's claim about a meeting purportedly held on 25th June 2022 has to be dealt with. It is the petitioner's case that Rashtriya Karyakarani meeting was held on 25th June 2022 and certain resolutions were passed. In support of this case, petitioner has produced certain resolutions of 25th June 2022. Those documents are disputed by respondents. Mr. Jetmalani, learned counsel for respondent, objected to the said documents being considered on the ground that they were forged and fabricated, and demonstrated this before me by showing two separate documents, one annexed by the petitioner Shri Sunil Prabhu to his affidavit in lieu of examination of in chief, and the other set of the same documents which are annexed to the Supreme Court Convenience Compilation Volume 2. In the first set of documents annexed to the affidavit in lieu of examination in chief, termed as minutes of the meeting of Rashtriya Karyakarani, and purportedly 7 resolutions passed in the said meeting. In none of the resolutions there is any signature of any person whose name are shown on the said document. Only on page 105 of Sri Sunil Prabhu's affidavit in lieu of examination in chief, there is a sole signature of Sri Vinayak Raut, who is shown as Shiv Sena secretary. The perusal of the said document shows that the meeting was termed as Rashtriya Karyakarani. In the second set of documents, which are annexed to the Supreme Court Convenience Compilation Volume 2, the resolutions are shown on different pages, and they are not part of any minutes which was annexed to the affidavit in lieu of examination in chief of Sri Sunil Prabhu. These resolutions are shown on the letterhead of Shiv Sena, Rashtriya Karyakarani Baitak into bracket Pratinidhi Sabha. Petitioner relied on these documents to show that 7 resolutions have been passed, but in none of these documents there is even a single signature, save and except for signature of 2 persons. The name mentioned as proposer and seconder are not even members of Rashtriya Karyakarani, like Sri Rahul Shevale, who is not a member of Rashtriya Karyakarani, who has stepped into the witnesses and led evidence that there was no such meeting. The same is the case with Sri Vinayak Raut and Sri Arvind Sawant. They are also not members of the said Rashtriya Karyakarani. The petitioner had claimed that the said meeting was held on 25/6/2022 at Sena Bhavan, whereas Sri Uddhav Thackeray claimed that the said meeting was held through video conference. This has been stated by Uddhav Thackeray in his submission before the Election Commission filed on 9/1/2023. This itself casts a doubt on the authenticity of the documents and holding of any such meeting of either Rashtriya Karyakarani or Pratinidhi Sabha. The petitioner himself is not sure whether it was Rashtriya Karyakarani or Pratinidhi Sabha. Thus, in view of the above said documents, the said documents cannot be permitted to be relied on. Petitioner suggests that a look into how the Shiv Sena settled conflict or decisions within the leadership structure in the past might shed some light into this. However, in the present matter, no such material are placed before me to even suggest such instances which happened in the past, where the majority decision within the leadership structure is taken as the will of the political party. It is to be also noted that the petitioner has neither placed nor provided any material to show that historically the decision of the majority within the leadership structure is taken to be the final decision of the political party whenever there was a conflict of decision within the leadership structure. Thus, for this reason also, it would not be appropriate and correct to accept the proposition that the decision of the majority leaders within the leadership structure would have to be accepted as one which conveys the will of the political party. As a passing note, I must also add that the majority rule possibly could have been applied in a normal situation where there is dissent in respect to some policy and or administrative decision of the party. However, such a simple rule stroke test shall not be applied to determine an essential question in existential question in relation to the political party, such as in the present matter, where which faction is the real political party is required to be determined. Thus, in view of the decisions recorded herein above, I am not inclined to accept submissions of the UBT faction that will of the majority leaders in the 2018 leadership structure is synonymous with the will of the political party. Thus, from paragraph 112 to 128, I have dealt with whether the relevant leadership structure read with the Shiv Sena constitution, SS constitution, provides answer to the question which faction is the real political party. In view of the same, I record my conclusion and finding thereon as under. (2018) leadership structure is not at all in conformity with the constitution of Shiv Sena and thus does not provide a reliable outcome and or answer to the question which faction is the real political party and hence cannot be relied upon to determine the preliminary issue. Decision of the Paksha Pramukh is not synonymous with the will of the political party and thus if there is a rift in the leadership structure, the decision of the Paksha Pramukh cannot be taken as the will of the political party. When there is a vertical rift in the horizontal leadership hierarchy of the political party and both the factions within the said leadership structure emerged as a result claim to represent the will of the political party, it would not be appropriate to apply the test of which of the said faction decision carries the will and wish of the political party. In the case of Shiv Sena political party, will of the majority leaders in the 2018 leadership structure cannot be said to be synonymous with the will of the political party. In view of the findings recorded in the preceding paragraph, I hold that the 2018 leadership structure read with the SS Constitution does not provide any reliable answer to the question which faction is the real political party and consequently the 2018 leadership structure cannot be yardstick to determine which faction is the real political party. With regards to the legislative majority, I am not going to spend much time because that question is rather clear. In view of the above observations and findings, I hold as follows. Which faction is the real political party is discernible from legislative majority which existed when the rival factions emerged. Legislative majority which existed when the rival factions emerged can be discerned and or inferred from 1. The Shinde faction resolution dated 21st June 2022 and 23rd June 2022 available on record of the legislature secretariat and the admitted position which can be inferred from the initiation of petitions against 38 legislators of Shinde faction by the UBT faction. Shinde faction had an overwhelming majority of 37 out of 55 MLAs with the when the rival faction emerged. From my analysis, observations, conclusions and findings recorded in paragraph 82 to 144 herein above, I hold that Shinde faction was the real Shiv Sena political party when rival factions emerged on 21st June 2022. In view of my findings that the Shinde faction was the real political party when the rival faction emerged and that Shri Sunil Prabhu ceased to be the duly authorized whip from 21st June 2022, I further conclude that Shri Bharat Gogaole was validly appointed as the whip, as that was the reflection of the will of the Shiv Sena political party as on 21st June 2023. Following are the final conclusions, which is again a summary. Have the respondents incurred disqualification in terms of paragraph 21A of the 10th schedule of the Constitution on account of their acts, omissions and conduct? I will also read the final conclusion. Following are the final conclusions from the analysis, observations, conclusions, findings and rulings recorded from paragraph 82 to paragraph 158 herein above. I conclude as follows. Shinde faction was the real Shiv Sena political party when the rival factions emerged on 21st June 2022. Shri Sunil Prabhu ceased to be the duly authorized whip from 21st June 2022. Shri Bharat Gogaole was validly appointed as the whip of Shiv Sena political party on 21st June 2023. Shri Eknath Shinde was validly appointed as the leader of the Shiv Sena political party on 21st June 2023. Have the respondents incurred disqualification in terms of paragraph 21A of the 10th schedule of the Constitution on account of their acts, omissions and conduct? Petitioner has contended that the respondents are liable to be disqualified on various grounds. Both the petitioners and respondents' submission are recorded in section 2 herein above. The various grounds on which the petitioner based the plea for disqualification is dealt with, where the alleged conduct of the respondent is purportedly becoming totally incommunicado attracts disqualification under paragraph 2(1)(a) of the 10th schedule. Whether the alleged conduct of the respondents in purportedly becoming totally incommunicado attracts disqualification under paragraph 2 subclause 1 subclause A of the 10th schedule. The first ground on which the petitioner sought disqualification of the respondents is that the respondents became incommunicado. The submission cannot be accepted and the respondents cannot be held to be disqualified on this ground for the following reasons. The ground is a mere allegation, and apart from mere assertion that the respondents have gone incommunicado, the petitioner has not put forth any evidence or material to substantiate it. For instance, the petitioner has not provided any material about who was sought to be contacted and by whom, when such an attempt was made, etc. A mere unsubstantiated statement that the legislators have gone incommunicado cannot even be a ground to attract disqualification under paragraph 21A of the 10th schedule. When rival factions emerge in a political party, especially within the leadership, it is possible for both the factions to allege that the other faction has gone incommunicado. In such a circumstance, especially in the light of the law laid down by the apex court in Subhash Desai Supra, it would not be correct to hold any faction to have incurred disqualification for going incommunicado without first determining which of the faction is the real political party, reflecting the will of the political party. Also, having held that the Shinde faction was the real political party when the rival factions emerged, the submission of the petitioner that the respondents have gone incommunicado ceases to hold any meaning for the purpose of disqualification. On the 20th of June 2022, elections for the Legislative Council were held. In his cross-examination, Shri Sunil Prabhu, PW1, stated that all the MLAs were present for the same. In the face of this evidence, it would not be possible to accept that the legislators had gone incommunicado. Respondents have placed that they have been in touch with the UBT faction. They substantiated it by stating that Shri Milind Narvekar and Shri Ravindra Phatak, MLC, of the UBT faction, had gone to Surat and met Shri Eknath Shinde and other respondents on 21st June 2022 on the instructions of Shri Uddhav Thackeray. This fact was not denied by the petitioner Shri Sunil Prabhu when a suggestion was put to him in the cross-examination. In fact, the petitioner admitted that Shri Milind Narvekar and Shri Ravindra Phatak MLC of the UBT faction had gone to Surat and met Shri Eknath Shinde and other respondents. Also, three of the witnesses for respondents have testified that Shri Milind Narvekar and Shri Ravindra Phatak MLC of the UBT faction had gone to Surat and met Shri Eknath Shinde and other respondents. On 21st June 2022, on the instructions of Shri Uddhav Thackeray, the testimony stood the test of cross-examination and the petitioner could not establish otherwise. Thus, on this count alone, or this count also, it would not be possible to accept the legislators were incommunicado, Whether the deliberate absence of the respondent in the SSLP meetings purported to be held on 21st June 2022 attracts disqualification under paragraph 21A of the 10th schedule. The second ground on which the disqualification is sought is that the respondent deliberately remained absent in the SSLP meeting held on 21st June 2022. Petitioners relied on the attendance sheet register of the meeting dated 21st June 2022. After having considered the submission advanced on this ground, I hold that respondents cannot be held to be disqualified on this ground. In view of my conclusion that 1. The Shinde faction was the real political party when factions emerged, and 2. Shri Sunil Prabhu ceased to reflect the will of the political party from the moment the faction emerged. Thus, it would not be correct to say that Shri Sunil Prabhu had any authority to call any meeting of the SSLP. Hence, on this ground alone, petitioner's case that the respondents were liable to be disqualified for non-attendance of the meeting dated 21st June 2022 is liable to be rejected. Irrespective of the conclusion that may be reached about which faction was the real political party, respondents could not be held to be disqualified on the ground that they deliberately remained absent in the SSLP meeting held on 21st June 2022. This is because of the following reasons. Petitioner relied upon the attendance sheet of the 21st of June 2022 to claim that all those MLAs who were signed the said attendance sheet were present in the meeting, while those who did not sign were not present. Based on this document, the UBT faction claimed that respondents remained deliberately absent. A comparison of the original attendance sheet produced along with the affidavit in lieu of chief examination of the petitioner Shri Sunil Prabhu, PW1, with the copy of the attendance sheet produced and verified as a true copy along with the petition, reveals that the two do not match. There are glaring discrepancies. The copy claimed to be the original of the said attendance sheet has a handwritten date of 21st June 2022, whereas the copy verified as the true copy of the original produced along with the petition does not have it. Further, Shri Sunil Prabhu stated in his cross-examination that the documents relied as the attendance sheet was in fact a register of MLAs to whom the whip of 21st June 2022 was served and received. So, facts show: 1. There are glaring discrepancies in the said attendance sheet. 2. The statements of Shri Sunil Prabhu shows the document relied upon as attendance sheet of MLA present on 21st June 2022 is in fact a register of service and receipt of the whip dated 21st June 2022 of the MLAs. Thus, the said document is unreliable and cannot be taken as proof of non-attendance of respondents in the meeting held on 21st June 2022. Hence, on this count as well, petitioner's case that the respondents are liable to be disqualified for non-attendance of the meeting dated 21st June 2022 has to be rejected. Further, all the respondents have denied the receipt of any whip for attending the meeting on 21st June 2022. Countering this, petitioner Shri Sunil Prabhu in his affidavit in lieu of examination in chief stated that the whip for 21st June 2022 meeting was sent via WhatsApp by Shri Manoj Harishchandra Chaugle to Shri Prabhakar Kaye, PA of Shri Eknath Shinde. In the cross-examination of Shri Sunil Prabhu stated that the whip was sent via WhatsApp to all the respondents, who according to him were not traceable. However, petitioner has not offered any statement or any material to even suggest that such WhatsApp messages were sent to other respondents. Thus, the petitioner has failed to establish that whip stroke notice was served upon the respondents in petition number 2-15, directing them to attend the meeting on 21st June 2022. As to the service of whip on Shri Eknath Shinde, the only material produced by the petitioner is an alleged screenshot of the WhatsApp message sent by one Shri Manoj Harishchandra Chaugle to one Shri Prabhakar Kaye. This does not constitute proof of any notice whip was served upon Shri Eknath Shinde, directing him to attend the meeting on 21st June 2022. Further, a perusal of the aforementioned WhatsApp message allegedly sent to the PA of Shri Eknath Shinde shows that the said message was sent at 12:31 p.m. on 21st June 2022 for a meeting which was allegedly scheduled for 12:30 p.m. Thus, it is abundantly clear that none of the respondents were ever served any notice whip for the alleged meeting dated 21st June 2022. Hence, on this ground alone, also, petitioner's case that the respondents were liable to be disqualified for non-attendance of the meeting dated 21st June 2022 must be rejected. The third ground on which the disqualification of respondent is sought is that the respondents deliberately remained absent in the SSLP meeting held on 22nd June 2022. Petitioner relied on the attendance sheet register of the meeting dated 22nd June 2022. After having considered the rival submissions, I hold that respondents cannot be held to be disqualified on this ground in view of my conclusion that 1. The Shinde faction was the real political party when rival factions emerged. 2. Shri Sunil Prabhu ceased to reflect the will of the political party from the moment rival factions emerged. Thus, it would not be correct to say that Shri Sunil Prabhu had any authority to call any meeting of the SSLP. Hence, on this ground alone, petitioner's case that the respondents were liable to be disqualified for non-attendance of the meeting dated 22nd June 2022 must be rejected. Again, even if I was to take different view about which faction was the real political party, still the respondents could not have been held disqualified on the grounds that respondent deliberately remained absent in the SSLP meeting held on 22nd June 2022 for the following reasons. I am unable to accept the petitioner's submission that non-attendance of the SSLP meeting would make the respondents liable to be disqualified under paragraph 2, 1A of the 10th schedule. I am of the view that non-attendance of party meetings, including legislature party meetings, would not attract disqualification under paragraph 2, 1A of the 10th schedule of the Constitution. Such an action cannot indicate that the members have voluntarily given up his membership of the political party. Not attending party meeting and voicing a difference of opinion outside the house are matters between the members and his party and have nothing to do with clause 2(1)(a) of the 10th schedule. Non-attendance of the meeting can at the most be termed as an act of dissent within the party. If viewed as a form of expression, it would be protected by freedom of speech and expression, which includes dissent and is not only an integral part of fundamental rights under Article 14, 19 and 21 of the Constitution, but is an aspect of the basic structure of the Constitution also. Therefore, even if the alleged non-attendance is seen as an expression of dissatisfaction, it cannot be treated as conduct attracting disqualification within the purview of paragraph 2(1)(a) of the 10th schedule. Further, I find the petitioner's reliance on Shriman Bayasaheb Patil versus Karnataka Legislative Assembly 2020 2 SCC 595 is misplaced, as in that matter the disqualification was not only on the grounds of non-attendance of a party meeting but was found to attract disqualification when considered with the surrounding circumstances, such as non-attendance of the assembly session along with non-attendance of meetings. Petitioner relied upon the attendance sheet of the 22nd June 2022 to claim that all those MLAs who had signed the said attendance sheet were present in the meeting, while those who did not sign were not present. Based on this document, UBD faction claimed that respondents remained deliberately absent. A comparison of the original attendance sheet produced along with the affidavit in lieu of chief examination of the petitioner Shri Sunil Prabhu PW1 with the copy of the attendance sheet produced and verified as a true copy along with the petition reveals that the two do not match. There are glaring discrepancies. The copy claimed to be the original of the said attendance sheet has a handwritten portion on top in which it is not which is not present in the copy annexed to the petition, verified as the true copy of the original. The original of the said attendance sheet has 17 signatures, and in the copy annexed in the petition, verified as true copy of the original, has only 15 signatures. Thus, glaring discrepancies in the said attendance sheet makes the said document unreliable and hence cannot be taken as proof of deliberate non-attendance of respondents in the meeting held on 22nd June 2022. Hence, on this count as well, petitioner's case that the respondents are liable to be disqualified for non-attendance of the meeting dated 22nd June 2022 is liable to be rejected. In view of my conclusions reached above and the findings that the Shinde faction was the real political party when rival factions emerged, it would not be correct to say that respondents have incurred disqualification under paragraph 21A and the 10th schedule by passing the resolution dated 21st June 2022. Hence, on this ground alone, petitioner's case that the respondents are liable to be disqualified for passing the resolution dated 21st June 2022 must be rejected. The next ground on which disqualification of respondents is sought is that the respondents acted in concert with BJP. This ground is a mere allegation, and apart from the mere statement that the respondents have acted in concert with the BJP, the petitioner has not provided any material to substantiate the same. Thus, a bald, unsustained statement that the legislators have acted in concert with the BJP cannot be a ground to attract disqualification under paragraph 21A of the 10th schedule. The next ground on which the petitioner seeks the respondents' disqualification is that they made anti-party, anti-coalition statements. Again, this ground is a mere allegation, and apart from a mere statement that the respondents have made anti-party, anti-coalition statements, the petitioner has not provided any material to substantiate the same. Newspaper/media reports relied on the petitioner cannot be taken as conclusive evidence of anti-party activities. It can at most be only considered hearsay. Thus, a mere unsubstantiated statement cannot be ground to attract disqualification under paragraph 21A of the 10th schedule. In conclusion, I would like to make some observations about dissent, indiscipline, and what acts as indiscipline would attract disqualification under the 10th schedule. If some member or members in a given case go overboard and make some statements or do some acts which may be considered indiscipline, it would be for political party to deal with them appropriately. Looking at the degree and gravity of the indiscipline, the concerned member may be censored, admonished, or reprimanded, or given a mere extreme punishment such as suspension or expulsion from the party as may be warranted by party rules. The 10th schedule is not intended as a device to be used for imposing intra-party discipline, much less for administering the party. No party leadership can use the provisions of the 10th schedule as a deterrent to stifle the collective dissent of large number of members by threatening them with disqualification under the 10th schedule. In a given case, when a tussle for leadership arises between leaders in a political party, the elected members, as indeed the common party workers, usually cannot remain mute onlookers. They are compelled to choose sides. Wherever whatever else may be the consequences of this action or inaction, the parties cannot expect that the high office of the Speaker can be used to eradicate opposition or quell dissent in party ranks by employing the mechanism of the 10th schedule. In any case, the Speaker has no role to play in this game of political tussle between warring party leaders. The Speaker merely goes to the letter of the law and the spirit behind introduction of penal consequences in the 10th schedule, which in my considered view is to preserve the democratic foundations of the legislature or the parliament. I must keep in mind this object underlying the 10th schedule and ensure that the dispute falls within the provisions of paragraph 21A and B, and that his powers are not sought to be invoked with ulterior motives for party gain. In view of my conclusions and findings recorded herein above, petition number 1 to 16 of 2022 are hereby dismissed. Group 3 deals with petition number 18, which is also under paragraph 21A. So I am only reading the operative part because the preliminary issues, the ruling will be the same on that. So I'll go to the operative part of it. You can deal with the judgment order with regards to the other aspects. Yeah. In view of my conclusion and findings recorded herein above, petition number 18 of 2022 is hereby dismissed. Group 4, petition number 19, which is filed by legislator belonging to the UBT faction under 21B, challenging the defiance of whip in the Speaker's election. Petitioner has contended that the respondents are liable to be disqualified on various grounds. Both the petitioners and respondents' submission are recorded in section 2 herein above. However, the prayer for disqualification in the present petition is restricted to the alleged violation of whip dated 2nd July, allegedly issued by the petitioner in respect of the election of the Speaker held on 3rd July 2022. Other averments are all repetitions of submissions in petition number 1 to 16 and petition number 18 of 2022. Thus, my finding thereof may be read and referred to in respect of the averments under paragraph 2, subclause 1, subclause A of the 10th schedule. Thus, the only ground on which the petitioner sought disqualification of respondent is that the respondent has violated the whip dated 2nd July, allegedly issued by the petitioner in respect of election of the Speaker held on 3rd July 2022. This submission cannot be accepted and the respondents cannot be held to be disqualified in view of my conclusion in respect of the real political party that the Shinde faction was the real political party when the rival faction emerged, and Sri Sunil Prabhu ceased to reflect the will of the political party from the moment rival factions emerged. Thus, it would not be correct to say that Sri Sunil Prabhu has any authority to issue any whip on 2nd June 2022. Hence, on this ground alone, petitioner's case that the respondents are liable to be disqualified for violation of whip dated 2nd July 2022 must be rejected. Irrespective of any conclusion that may be reached about which faction was the real political party, respondents could not be held to be disqualified on the ground that they violated the whip dated 2nd July 2022. This is because of the reasons recorded herein below. The petitioner has failed to prove the service of whip dated 2nd July 2022. Petitioner Shri Sunil Prabhu PW1 in his affidavit in lieu of examination in chief deposed that the whips dated 2nd July 2022 were sent by email to the email address of the respondents. He stated that Shri Vijay Joshi, an employee working in the Shiv Sena Vidhimandal Karyalay, Vidhan Bhavan, was instructed to send the whip. He further deposed that 2 whips dated 2nd July 2022 were sent by Shri Vijay Joshi to the respondents in disqualification petition number 19 and 21 of 2022. We did 3 emails dated 2nd July 2022. The said emails were produced along with the affidavit in lieu of evidence in chief. He further stated that email addresses of the respondents were taken from the email addresses mentioned in the official list of members of Maharashtra Legislative Assembly 2023 or as mentioned in a list furnished by the advocates for the respondents. We did the email dated 21st September 2023. Shri Vijay Joshi, PW2, specifically filed affidavits in lieu of examination of chief and deposed that he was working in the Shiv Sena Vidhimandal Karyalay, Vidhan Bhavan, in June 2022 and on instructions of Shri Sunil Prabhu sent 2 whips dated 2nd July 2022 to the MLA of Shiv Sena Legislature Party. We did 3 emails. He produced printouts of emails dated 2nd July 2022 along with whip dated 2nd July 2022. However, during the cross-examination of Shri Vijay Joshi, PW2, he deposed that one computer operator printed the whip dated 2nd June 2022 and he along with 2 peons distributed the whip to all the legislators of Shiv Sena. Further, he also deposed during cross-examination that acknowledgements were taken. Thus, the witness who was specifically brought to depose in respect of the service of whip dated 2nd July 2022 made extremely contradictory statements in the affidavit in lieu of examination in chief and during cross-examination. Further, it is to be also noted that the acknowledgement talked about by Shri Vijay Joshi, PW2, were never brought on record. Coupled with the above facts, respondents have demonstrated how some of the email IDs in the printout of the email produced by Shri Vijay Joshi are wrong. In view of the above, I hold that petitioner has not been able to establish the service of whip dated 2nd July 2022 and thus petitioner's case that the respondents were liable to be disqualified for violation of whip dated 2nd July 2022 must be rejected. Rule 3 subclause 5 of the members of Maharashtra Legislative Assembly disqualification on the grounds of defection rule 1986 provides that where a member belonging to any political party votes or abstains from voting in the assembly contrary to the directions issued by such political party or by any person or authority authorized by it in this behalf without obtaining in either case the prior permission of such political party, person or authority, the leader of the legislative party concerned, or shall as soon as may be thereafter and in any case within 30 days from the date of such voting or abstention inform the speaker as in form 2 whether such voting or abstention has or has not been condoned by such political party, persons or authority. From the record of the Legislature Secretariat, it is seen that the petitioner and or UBD faction has not complied with this rule. Thus, on this ground also, petitioner's case that the respondents were liable to be disqualified for violation of whip dated 2nd July 2022 must be rejected. The Honorable Supreme Court in Kyoto Holohan and others at paragraph 123 SCC has held that, keeping in view the consequences of the disqualification, i.e. termination of the membership of a house, it would be appropriate that the directions or whip which results in disqualification under paragraph 21b is so worded as to clearly indicate that voting or abstaining from voting contrary to the said direction would result in incurring the disqualification under paragraph 21b of the 10th schedule, so that the member concerned has foreknowledge of the consequences following from the conduct in voting or abstaining from voting contrary to such a direction. A perusal of the whip dated 2nd June 2022 shows that the whip dated 2nd June 2022 does not contain any words which would indicate that the said whip, if not allowed, would result in the disqualification. Thus, on this count as well, petitioner's case that the respondents were liable to be disqualified for violation of the whip dated 2nd June 2022 must be rejected. At this juncture, I intend to look into respondent's submission that a whip cannot be issued in an election to the post of speakers has to be considered, even though the learned counsel for the petitioner submitted that in normal course of events no whip is issued for the election of the post of the speaker, but he submitted that the election held on 3rd July 2022 was not in normal course, but it was crucial event linked to the sustenance of the government. Petitioner further submitted that in any election where a candidate has been set up by the political party, then in that case the directions of the political party are binding on the legislator in important elections. At the outset itself, I must state that the record that the petitioner's submission that in a speaker's election candidates are set up by a political party is factually wrong. As a convention, the candidates are not usually seen as candidates set up by political party. In the present case also, Sri Rajan Salvi was not set up as a candidate of Shiv Sena, but his notice of nomination was moved by a legislator affiliated to the NCP and seconded by legislator affiliated to the INC. This clearly indicates that candidates for the election of speaker are not set up by political parties. In view of the same, the petitioner's own submission, a whip could not have been issued in the election of a speaker as the candidate was not set up by any political party. In view of my conclusions and findings recorded herein above, petition number 19 of 2022 is hereby dismissed. Petition number Group 6, which consists of petition number 21, again filed by a legislator belonging to the UBT faction under 2(1)(b) for defiance of whip issued during the confidence motion. I will only read the operative part and you can refer to the judgment for the details. The preliminary issue has already been decided in the previous orders, so that will apply to this as well. In view of my conclusions and findings recorded herein above, petition number 21 of 2022 is hereby dismissed. Now we shall deal with Group 5, being petition number 22 to 24, which have been filed by legislator belonging to the Shinde faction under paragraph 2(1)(a) and paragraph 2(1)(b) of the 10th schedule of the Constitution of India. Again, here I am not dealing with the preliminary issue which has already been ruled in the previous order. So I will directly go disqualification petition number 20 and 22 to 34 of 2022 has been filed by the petitioner Shri Bharat Gogawale against Shri Nitin Chandrakant Deshmukh and 13 other members of the 14th Maharashtra Legislative Assembly under paragraph 21A and paragraph 21B of the 10th schedule of the Constitution, inter alia on the following grounds: that A. Respondents have by their conduct voluntarily given up their membership of the SSLP, and 2. Respondents have voted against the whip issued on 3rd July 2022, wherein all members of the SSLP were issued directions to vote in favor of the confidence motion held on 4th July 2022. I'll straight away go to my analysis, observations and findings. The issue as to which faction was the real political party when the rival factions emerged and who was the duly authorized whip and the leader has been extensively discussed and decided in disqualification petition 1 to 16, group number 1. Since the genesis of both this group and the said group is the same, the preliminary issue is common. Thus, the said decision on preliminary issue decided in disqualification petition number 1 to 16 of 2022 be read as the decision hereunder. Petitioner has contended Petitioner has contended that the respondents are liable to be disqualified under paragraph 21A of the 10th schedule. This submission cannot be accepted and the respondents cannot be held to be disqualified on the grounds for the reasons that this ground is a mere allegation, and apart from mere assertion that the respondents have voluntarily given up the membership of SSLP, the petitioner has not put forth any evidence or material to substantiate it. A mere unsubstantiated statement that the legislators have voluntarily given up the membership cannot be a ground to attract disqualification under paragraph 21A of the 10th schedule. I have perused my record as well as a copy of the whip issued by the petitioner, which is signed by the petitioner as Chief Whip and Shri Eknath Shinde as the leader of the legislature party. Though the petitioner tried to show that the said whip was served and delivered on the respondents, the petitioner has failed to prove the service of the whip on each and every MLA of Shiv Sena. I have also examined in detail the cross-examination of the petitioner, Shri Bharat Gogawale, and have found major inconsistency in the answers regarding physical service of the whip, and therefore this evidence cannot be accepted. Insofar as delivery by WhatsApp is concerned, the same also was produced on the last day of the evidence despite ample opportunity for the same. Even the pleadings filed by the petitioner are silent on the issue of service. In these circumstances, it will not be justifiable for me to take on record a document purporting to be a screenshot of WhatsApp messages which were admittedly sent through a third person mobile number, i.e. one Mr. Santosh Kadam, who also did not step into the witness box. Thus, petitioner's plea to disqualify respondents cannot be accepted. The Honorable Supreme Court in Kyoto Hulyan at paragraph 123 SCC has held that, keeping in view the consequences of the disqualification, termination of the membership of a house, it would be appropriate that the decision of whip which results in such disqualification under paragraph 21B is so worded as to clearly indicate that voting or abstaining from voting contrary to the said directions would result in incurring the disqualification under paragraph 21B of the 10th schedule, so that the member concerned has foreknowledge of the consequences following from his conduct in voting or abstaining from voting contrary to such a direction. A perusal of the whip dated 3rd July 2022 shows that it does not contain any words which would indicate that the said whip, if not allowed, would result in disqualification. Thus, on this count as well, the petitioner's case that the respondents are liable to be disqualified for violation of whip dated 3rd July 2022 must be rejected. Rule 3 subclause 5 of members of Maharashtra Legislative Assembly disqualification on grounds of defection rule 1986 provides that where a member belonging to any political party votes or abstains from voting in the assembly contrary to any directions issued by such political party or by any person or authority authorized by it in this behalf without obtaining in either case the prior permission of such political party, person or authority, the leader of the legislature party concerned or shall as soon as may be thereafter and in any case within 30 days from the date of such voting or abstinence inform the speaker as in form 2 whether such voting or abstinence has or has not been condoned by such political party, person or authority. From the records of the legislature secretariat, it is seen that the petitioner has not complied with this rule. Thus, on this ground also petitioner's case that the respondents are liable to be disqualified for violation of whip dated 2nd July 2022 must be rejected. In view of my conclusion, the findings recorded herein above, petition number 20 and 22 to 34 of 2022 are hereby dismissed. Group 2, petition number 17 against 2 independent MLAs and 1 Mr. Bachchu Kadu of PJP party. The same are dismissed. Yeah, you can apply for certified copies. We'll provide you with a mail as well as hard copies.